Bill O'Leary here today to talk about what estate planning documents are needed. So in this video, you're going to learn three things. One, how to get your affairs in order. Two, how to get started. And three, the critical legal documents you need to get your affairs in order. First, a little bit about me. Again, my name is Bill O'Leary. My firm is Legacy Planning Law Group. I'm an attorney in Jacksonville, Florida, and I focus on things like estate planning, elder law, and probate and estate administration. Look, do your loved ones a big favor. Get your affairs in order so you don't leave them to face a legal mess after you're gone. Many of us want to get on with this planning, but don't know where to start. Well, here's what you should know about the most important legal documents that can help you get your affairs in order. Number one, having a will, last will and testament. A will gives you the power to decide four very important questions that are important and personal to you. Number one, who gets your stuff? Number two, what they get. Number three, when they get it. And number four, how they get it. Who, what, when, and how. Answering these questions down on paper is very important because guess who answers these questions for your loved ones if you don't do so? The state, the government comes in and answers these questions, and it may not be the plan that you want. A will also allows you to decide what's in the best interest of your children and even your pets after you're gone. You can also decide who's going to get your personal belongings like jewelry and furniture. Another important purpose of a will is to name guardians for minor children. And oh, by the way, if you're married, your spouse needs a separate will. You can't have a joint will. The next important estate planning document is a living trust. A living trust is a commonly used estate planning tool, and it's a great alternative to a will. It's a great alternative to a will. A living trust, again, allows you to answer those same four questions that a will does: who gets your stuff, what they get, when they get it, and how they get it. So if a will answers those four questions and a living trust does as well, then which one is better? Real simple. A living trust will make things smooth and easy for your loved ones after you die by making sure they don't get stuck in the probate court. With a will, probate often is required. Not so with a living trust. So creating a living trust, just FYI, it's not a do-it-yourself project. Don't try this at home. Get expert help from an estate planning attorney. The next thing to focus on as part of a good estate plan is the beneficiary designations. When you buy life insurance or things like a retirement account or maybe an annuity or maybe even a bank account, you can often name a beneficiary, which is the person you want to inherit the proceeds when you die. These designations are powerful and they take precedence over instructions in a will. And what's nice is you can have a living trust in place and make the trust the beneficiary of these financial accounts. So look, keep beneficiary designation papers with your estate planning documents and review and update them as your life changes. The next important item is a durable power of attorney. A durable power of attorney allows you to choose someone to act on your behalf both financially and legally. It's sometimes called a financial power of attorney because, again, it focuses on financial matters. Don't put off this chore. You have to be legally competent to assign a power of attorney and to authorize someone to be in that decision-making role for you. And the problem we see is often older people are worried about relinquishing control to someone, and they often put this task off too long to the point where they're no longer competent to sign a power of attorney, and we have to get involved with the guardianship court. Not a good situation. And one other very important element of an estate plan: healthcare advance directives. Get a good set of healthcare directives in place. And this is going to give you, I tell you, peace of mind knowing someone's in place to make healthcare decisions for you if you can't anymore. You can also name people to have access to your health information and medical records. Advance directives also include something called a living will, which is think of it as an end-of-life document. It allows you to express your wishes for what kind of medical treatment or procedures you want if you, let's say, are close to death or have a terminal condition, or perhaps those procedures that you don't want, that you want withheld. And having a living will is great for your healthcare surrogate decision maker to have in hand, so they're not having to guess what your wishes would have been. So if you'd like to know more about the estate planning documents you need and maybe how we can help, we'd love to talk to you. So we invite you, we encourage you to take that initial first step. It's a simple step by scheduling a free 15-minute discovery phone call with us, which is a chance for you to share with us what's on your mind, and we can sort of start a conversation with each other. And we've made it very easy to schedule this call. So go ahead and click on the link below this video that takes you to our booking calendar. That's one way to get there. The other way is you can go to our website, legacyplanninglawgroup.com, and just find the blue book your free call button. It takes you to the same booking calendar. Just pick a day and time that works for you, and we'll get on the call at the time that you select. So this is Bill O'Leary signing off for now. And I just want to encourage all of you to go make it a great day and a better world.